What's up, everybody? No intro today. We're jumping right into it. I'm coming right from WFLA 8. We gave some analysis on there. We're going to watch the hearing here, give our commentary over it, add to it, because we like to talk through these things and explain what's going on over there. It's going to be kind of silence. If you want no commentary, go over to WFLA. We're going to be promoting their stream and their channel here as well. They're amazing. So I am going to share my screen here with the hearing. We will talk through it. We will answer your questions, and we will get everything done here as a fam like we usually do. So let me share my screen.
Involving the estates. So let's begin. Officer,
I'll back it up just a little so we can hear it from the beginning.
After the hearing is concluded.
And there's our boy JB. And let's see what happens.
I am electronically present in the courtroom today as I'm abiding by the court's quarantine protocols. We have technology in place to allow the court's work to continue without.
That's interesting. The judge isn't even there in person.
Hearings today, not simply these two cases, has been the same. The court is prepared. Whether you are joining us in person in the courtroom or via Zoom, welcome. There are two housekeeping items to address. First, only credentialed media authorized by the court's public information officer, as well as the court reporter, may record these proceedings in the courtroom or on Zoom. If you have not received that authorization in advance, you may not record these proceedings. Second, we have two cases this afternoon. The first case we will address involves the parents as parties in the lawsuit. We will complete that hearing before moving on to the second case, which is the case involving the estates. So let's begin. The court's going to first call the case of Joseph Petito and Nicole Schmidt versus Christopher Laundrie and Roberta Laundrie, case number 2022 CA 1128. Ask the attorneys to please make their appearances and introduce their clients if they're present.
Good afternoon, Your Honor. Patrick Riley Ford, sitting to my right, Joseph Petito, and also sitting to my right, Nicole Schmidt.
Thank you. Mr. Luca.
Good afternoon, Your Honor. Matt Luca on behalf of the defendants, Christopher and Roberta Laundrie, who are not present.
Thank you very much. Now
the judge is not present, he said, because he's abiding by the quarantine rules. So maybe he had COVID or was exposed or something. So he's appearing electronically. That's why he's not actually in the room.
Here to hear the motion to dismiss filed by the Laundries, which is at document identification number or DIN 33. The plaintiffs have filed a response, which is at DIN 38. And the defendants have filed a reply, which is at DIN 39. I've reviewed those filings as well as the other materials submitted by the parties. So, Mr. Luca, you have the floor, and if you'd like to go to the lectern, that would be great.
Yes, thank you, Your Honor.
I have to say, Your Honor, it's unusual to be staring at an empty spot up there at the bench.
Well, it is what it is.
Talk about awkward. You go up to the lectern, you open up your binder like Matt Luca's doing here, and you make your argument to an empty judge's bench in a hearing that you're arguing in front of a judge. It's very awkward and interesting. But hey, in these times, we keep trucking along. Back in the day, if the judge was sick, we'd have to just cancel the hearing. So we got to be thankful for technological advancements.
What do they tell actors, Your Honor? Just find a place on the wall and stare at that. Well, thank you, Your Honor, for your time this afternoon. I appreciate it.
No laughs. He got no laughs from that joke. I thought it was funny.
Your Honor, I won't spend any time going through the general standard on a motion to dismiss. I know Your Honor is well aware of that. So I'll just jump right in. Your Honor, our position is straightforward. A cause of action for intentional infliction of emotional distress was not intended to include liability for a defendant who does nothing, who has no contact with the plaintiff. All of our arguments regarding outrageousness, legally permissible conduct, causation, and the presence of the plaintiff all go back to that premise and show why there is no legal footing for this cause of action in this context. Conduct that amounts to remaining silent and maintaining privacy is not intentional infliction of emotional distress. And there are no cases where such conduct was found to be intentional infliction of emotional distress. Rather, plaintiffs argue that the Laundries had an obligation, a duty to speak. The law imposes no such obligation to speak, and the state and federal constitutions support that. In our society, under our laws, people are free not to speak. Your Honor, the elements of the cause of action alleged are a deliberate or reckless infliction of mental suffering, outrageous conduct, the conduct caused the emotional distress, and the distress was severe. I'll first address the outrageous conduct element, Your Honor. So the standard for determining whether or not conduct is outrageous is that the behavior claimed to constitute the intentional infliction of emotional distress must be so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency. That is conduct that is atrocious and utterly intolerable in a civilized society. It is an objective standard, and the subjective response of the plaintiffs is not what controls. The issue of whether or not conduct is outrageous is a question of law and for the court to decide. And that standard is extremely high in Florida. It is not enough that the defendant acted with an intent which is tortious or even criminal, or that the defendant intended to inflict emotional distress, or even that the defendant's conduct can be characterized by malice or a degree of aggravation which would entitle the plaintiff to punitive damages for another tort. Now, Your Honor, looking at the amended complaint in this case.
So he mentioned something about punitive damages, which is why intentional infliction of emotional distress is a very specific statute and cause of action. It's different than negligent infliction of emotional distress. It brings with it potentially more punishment and more damages if you are able to get a verdict under this cause of action, potentially. So it is a high bar because it is a very, very serious cause of action. And I want to take a second to answer Nicole's question and Allison's question about the Laundrie's parents are not there. Why aren't his parents there? A lot of people are asking. They do not have to be there in a civil case. Actually, it's more common for civil parties on both sides to not be there for every hearing and every motion that happens in a case. It's actually less likely that they show up, but there are cameras here and this is a high profile case. So maybe we'll see more of the Petito parents or Laundrie parents. Maybe we'll see, but at this point we don't. They are not required to be there. And I don't really think it says anything about it one way or the other personally, but you all are free to disagree, of course, as the court of public opinion, because that matters, as we saw in the Johnny Depp case.
Paragraph 32 provides a summary of what the plaintiffs alleged is the conduct that was outrageous. So they allege first, failing to advise the plaintiffs that Ms. Petito was deceased. Second, failing to disclose to the plaintiffs the location of Ms. Petito's body. Third, taking a family vacation with their son, Brian Laundrie, who they alleged had murdered Ms. Petito while the plaintiffs were looking for Ms. Petito. Fourth, blocking access to their cell phone and Facebook page to preclude the plaintiffs from contacting them and getting information regarding Ms. Petito. And finally, that the Laundrie's attorney, not the Laundries themselves, issued a statement to the press expressing hope that the search for Ms. Petito is successful and that Ms. Petito is reunited with her family.
Is there a distinction between the attorney doing it on behalf of the Laundries versus the Laundries?
Well, Your Honor, the attorney is obviously not a defendant in this case, and there are no allegations that within the complaint that the Laundries directed the attorney to make that statement, what information the attorney had with regard to making that statement. So I do believe that there is a distinction, Your Honor.
isn't.
So I don't know why that matters, because what the attorney said was positive. He wasn't hiding anything. But just to give you guys all a heads up, so Joe Gottman wants to know what does pretrial mean? All these hearings and motions and things that happen before the trial starts, that's known as the pretrial phase, which is what we're in now. Additionally, if you notice, that voice you hear asking questions is the judge. So unlike a jury trial, when you're at a hearing like this is kind of like an appellate hearing, where if the judge wants to know certain things, the judge, like I said, is very smart, a very good judge, was a very good lawyer, had clients before. He's read all of this material. So the fact that he's read all this material lets you know he is going to pick out things that he thinks are interesting or he's not sure about, or that may sway his decision, and he's going to pepper the lawyers with questions on those topics. Well, obviously, the judge thinks that there may be an issue with the lawyer's comments. And we know, based on the Johnny Depp case, that the lawyer's comments can get you into trouble and can be held to be your comments as an agent. One of the other things that's interesting, if the judge ends up granting this motion to dismiss without prejudice, meaning the plaintiffs can go amend the complaint and refile it, the plaintiffs know that the judge think this is important. And Matt Luca's response was, well, there's nothing in the complaint that says anything about the lawyer's statements or that the client's directed the lawyer. Now they can go back, change the verbiage in the complaint to potentially add something about the lawyer and what the lawyer said as the client's agent, and maybe come back with a complaint that this judge likes better or that this judge thinks will pass muster. It's very, very interesting. And Elza, real quick, do you have to be there in a criminal case? In some of them, yes, but you can waive your appearance in some misdemeanor cases with a motion. So it depends, but yes, more likely in criminal cases will the client show up versus the civil cases. The judge has another question. Let's hear what it is.
Under Florida law, isn't the attorney the agent of the client?
I do agree with that, Your Honor.
Then why does it matter that the attorney and not the Laundries themselves made the statement?
Well, Your Honor, what we don't know, what is not alleged in the complaint, is whether their attorney was making that statement on behalf of the Laundries or whether he was making that statement in his personal capacity.
Well, on a motion to dismiss, how am I supposed to construe the well-pled allegations?
The answer is in a light most favorable to the plaintiff. It's moving towards, if he does already very early on, it's moving towards, I think the judge is going to either deny this motion to dismiss or grant it with leave to amend, so without prejudice.
Your Honor, on a motion to dismiss, I would argue to the court that by not alleging in the complaint that the attorney was the agent of the plaintiff, or I'm sorry, of the defendants for purposes of making that statement, that they have that the plaintiffs have not alleged sufficient conduct that would cause liability for the defendants for the statement by their attorney.
Well, assume for the sake of argument, the court concludes that there was sufficient allegations that the attorney is the agent for the Laundrie. So assume that to be true. Now we have a situation where the Laundries themselves are making a statement and not standing silent. So what does that do to your argument about staying silent?
Your Honor, I still don't think it necessarily makes a difference. I mean, I understand what.
That's the right answer. It doesn't make a difference, I don't think, whether they remain silent or said something like that. They weren't, I mean, to me, that statement is not outrageous. You guys let me know, because it's supposed to be a reasonable person. So the Laundrie attorney saying, we hope Gabby returns soon, is that outrageous? I guess you'd have to prove that, again, they knew and were concealing things, which I'm not sure we know. But in the complaint, they say that the Laundrie parents knew and were concealing things. And right now, in this situation, in a motion to dismiss, we have to believe everything the plaintiffs say is true. And if it is true, do they have a cause of action? So they're trying to build on that. And it seems like the judge is tracking where the plaintiffs are going in this case.
What the court's saying, that that if we impute that statement to the defendants, that would not be complete silence by them. However, the defendants do have a constitutional right to have an attorney and to have that attorney speak. So again, Your Honor, in my view, the attorney was merely exercising the constitutional rights of both the attorney and of his clients by making a statement.
Okay, but when you make an affirmative statement, that's the antithesis of staying silent, right?
I would agree with that, Your Honor. Yes.
You may continue.
Thank you. Your Honor, The plaintiff's claim of outrageous conduct in this context is novel. The plaintiffs have cited no cases where a person's silence with accept.
Novel means they haven't worked in the past. We don't have a bunch of cases that say this is appropriate, you can keep going. So novel is not necessarily a good thing legally, although sometimes it does work and you can be groundbreaking. But legally speaking, you like to copy off of what's happened in the past because we know how it's going to go in the future. And that's your best chance to win a case. And that's your best chance to tie the hands of a judge.
Except with regard to what Your Honor just raised with regard to their attorney's statement, was considered outrageous regardless of the circumstances. And they certainly haven't cited any cases where a statement by a person's attorney has been considered outrageous. All of the cases they've cited involve some action by the defendant. Accepting the allegations of the amended complaint as true and allowing the case to proceed further would require any person and their family to speak about an alleged crime or other tragic event of which they may or may not possess knowledge. And that is simply not something that our legal system requires. For example, if a family member came to me and told me that they did something terrible, the plaintiffs want the law to impose an obligation on me to then report what that family member told me. And that just isn't the law. Even if that, I'm sorry, go ahead.
Let me make sure I understand what you're saying. Are you saying that they came to you in your capacity as a lawyer or as just a normal person?
Just a normal person, Your Honor, just a family member.
Okay, well, does Florida recognize a privilege, a parent-child privilege?
Your Honor, I'm not arguing privilege. This could be somebody who is not a parent, a child, a wife, a husband, just anybody. My argument is not that there was a privilege between Brian Laundrie and his parents. My argument is that even if Brian Laundrie conveyed information to his parents, that they don't have a requirement then to speak with regard to that information.
So another point that the judge clearly wanted to hit on and talk to Mr. Luca about, and that is whether or not there is a parent-child privilege in Florida. He asked the question, knowing that the answer was no, and it was not in Luca's motion to dismiss. If it was an argument, he would have made it in there, and he didn't. So it's very, very interesting because we're listening and we're looking at what the judge thinks is important, and that's what we get to know.
They don't have to share it.
Okay, well, let's go down that road for a moment, because this is where I'm having some difficulty. I fully understand and get the constitutional right to remain silent. That being said, we're on a motion to dismiss on a complaint where I have to assume the facts are true.
Sorry, I'm pausing it so much, but the judge is giving us so much here as to what he thinks. He understands the constitutional right to remain silent, that Fifth Amendment right. But right now we're here on a motion to dismiss. So to me, he's indicating, Laundrie's, you guys might win later on a motion for summary judgment, but I'm not so sure you're going to win on a motion to dismiss. The judge may allow this to go past this motion to dismiss phase, but he's indicating that maybe this Fifth Amendment right is going to cause them to win just later on, meaning the Laundries. Interesting. You can learn a lot listening to the judge's questions. Lawyers have to listen closely to this.
And you're trying to get me to say that the complaint itself demonstrates the existence of a right to remain silent. And I'm trying to understand how that is, or is that more of an affirmative defense that should be fleshed out in the pleadings?
Your Honor, I don't agree that it's an affirmative defense that needs to be fleshed out. I believe the court can, obviously the complaint alleges that the defendants were residents of the state of Florida, so the Constitution of Florida and the Constitution of the United States apply to them. And if you look at the complaint, Your Honor, even though it doesn't allege a formal criminal investigation, it doesn't use those magic words, so to speak, it does allege that Brian Laundrie murdered Miss Petito. It alleges that Brian Laundrie engaged in conduct to try to cover that up by sending text messages and things like that. It alleges that the defendants, his parents, the Laundries, were trying to help him escape the country. It alleges that the Laundrie family hired an attorney, and then once they hired the attorney, at that point, all the contact with the plaintiff stopped. And the only statement we have is that one statement by their attorney that the court referenced. So under those circumstances, as alleged in the complaint, Your Honor, that's enough for the court to say somebody in that situation could invoke their Fifth Amendment privilege. That's not something that the court would need to find additional facts. The court does not need to look outside the four corners of the complaint. There are sufficient allegations within the complaint that would trigger somebody in that situation exercising their Fifth Amendment privilege. Your Honor, would you prefer for me to continue with the outrageous element or move on to the legally permissible element, since that seems to be
Whichever way you want to go.
Okay, thank you, Your Honor.
I'm not shy in asking questions.
I understand. Your Honor, the plaintiff's cause of action could also extend to somebody who, may not be in the situation where they were told something, but maybe they witnessed something, or maybe they came upon some evidence, and somehow they had some information that might be relevant to some tragic event. The plaintiff's cause of action would impose an obligation on people like that to contact the families who may be involved in that situation and disclose what they knew, or they would fear being sued. The slippery slope of allowing this cause of action to proceed would really require anyone with knowledge of events that are hurtful or which cause emotional distress to another to convey their knowledge or potentially be exposed to liability.
So while I think this is one of his best arguments, the slippery slope, it's not quite that far. And when you take it too far, I think sometimes it sounds a little disingenuous, because Gabby Petito's parents can say, no, not everybody has to come forward. But when everybody knows you know something, and we as the plaintiffs ask you specifically, and then you remain silent, that's different than just people voluntarily coming forward. I'm not saying I agree with that argument, but at least they would have a response to Mr. Luca's argument. And let me take a couple questions here from some members. Pesky Pirouette. I thought the Fifth Amendment was to not implicate yourself. So were the Laundrie parents there when GP was murdered? I'm confused. No, but covering up a murder or an accomplice after the fact, they could be implicating themselves criminally. Therefore, they do have a Fifth Amendment right to remain silent. Beverly Alford. I'm not dogging the court at all, but shouldn't he know the answers to these questions? He knows the answers. That's the point. That's why he's asking the question. He's asking a question, but what he's really doing is saying, aren't you going to lose because of this? Explain to me why you're not going to lose because of what the answer is to this question that we both know. Sometimes they're also asking to see if the lawyer knows. And I've seen some lawyers give wrong answers, and the judge said, no, that's actually not the state of the law in Florida. So he does know the questions, and he's reviewed the material. That's why he's asking him this way. Melanie Casio. By pleading the Fifth, does that suggest guilt to the court? No, not to the court. Maybe to the public, but the court's not just going to automatically think somebody's guilty because they exercise their Fifth Amendment right. All right, back to it.
Now, the underlying crime.
But again, I go back to, there's an allegation that the Laundries made an affirmative statement and put out into the public various statements. So am I not supposed to consider that conduct because that's a voluntary act by the Laundries?
I understand, Your Honor, and I assume you're referring to the one statement by the attorney alleged in the complaint. Assuming for the sake of argument that is an affirmative statement by the Laundries, Your Honor, you can definitely consider that. But again, in the context of the overall case, is that statement alone sufficient to meet the standard for outrageousness? If, let's say, for example, I had, some knowledge about a crime that somebody committed, and I made a public statement about some aspect of that case, but I didn't share everything that I knew, or I hedged my bet, so to speak. Would I then be subject to liability because I shared something, but I didn't share other things? That's really the question, Your Honor.
You can't have it that way.
What are we going to require of people in a situation like this? Are we going to require
He's
them to
right.
say everything that they know? or are they going to be allowed to speak freely or not speak at all? That's really the question before Your Honor.
Yes, Kat, this and other things.
And Your Honor, I think it's important to keep in mind the standard that we're talking about here, that the conduct has to be atrocious and utterly intolerable in a civilized society. You know, people
Thank
who
you,
are
Pesky.
faced with difficult challenges have to make difficult choices. In our society, which I would propose is civilized, recognizes at its core that things like remaining silent or speaking through an attorney are foundational rights. And those are choices that our society considers entirely tolerable. And in fact, they're codified in our founding documents. So, Your Honor, even considering the statement by the attorney, I would submit to Your Honor that's not atrocious. It's not intolerable in a civilized society for their attorney to make a statement for them like that. Your Honor, another thing I'd like to address that the plaintiffs raised in their response is that the Laundries were somehow in an unequal position to
Before he gets to this argument, that argument he just made that this has to be so outrageous and so horrible what happened. Let's make sure we're separating conduct here. Nobody is arguing that what Brian did to Gabby, based on all reports, is not outrageous and horrible. Nobody's arguing that. What we're talking about here in this case is exercising your Fifth Amendment right to remain silent. Is that so horrible and outrageous that they should have a claim like this? And if so, how would that affect other cases in the future? That's kind of one of the questions that we're discussing here.
To the plaintiffs, and that made their conduct particularly outrageous. Your Honor, I don't think that the standard for unequal positions is really what the plaintiffs would qualify that under this circumstance. Your Honor, in Dependable Life Insurance Company versus Harris, which is a 5th DCA case from 1987, it's cited in our papers. Your Honor, in that case, and what the plaintiffs rely upon is Restatement of Torts, Section 46, Subsection E, which states this unequal position argument. And what the restatement says is, the extreme and outrageous character of the conduct may arise from an abuse by the actor of a position or a relation with another which gives him actual or apparent authority over the other or the power to affect his interests. Thus, an attempt to extort money by a threat of arrest may make the actor liable even where the arrest or the threat alone would not do so. In particular, police officers, school authorities, landlords, and collecting creditors have been held liable for extreme abuse of their position. Even in such cases, however, the annoyances that are not extreme, even in such cases, however, the actor has not been held liable for mere insults, indignities, or annoyances that are not extreme or outrageous. So, Your Honor, in Harris, what the court recognized there is that the result of this unequal position must be something that is akin to extortion, meaning that somebody threatens another person based upon their position to cause some harm. Like, you know, I'm gonna cause you to lose your job. I'm gonna cause you to be arrested. I'm gonna hurt your family, something like that. That's really what it's about. It's about somebody who has some authority to affect the person's life. It's not a situation where somebody might have information that another person doesn't have and they simply don't share it. That's not really what the Harris case or what the restatement are talking about when they say unequal positions. Now, Your Honor, moving on to the assertion of illegal rights. The standard with regard to that element is that the conduct, although it would otherwise be extreme, such insistence is certain to cause emotional distress. Now, we have several rights at play here, Your Honor. You brought up one earlier, the Fifth Amendment right to remain silent. That is certainly one of them. There's also the First Amendment right of freedom of thought, which would include both the right to speak freely and the right to not speak at all. And that was cited in Woolley versus Maynard, a Supreme Court case from 1977. Again, it's in our papers.
Aren't we responsible for the words that we say when we say them?
I would agree with that, Your Honor. Certainly, if you say words.
Johnny Depp just got found civilly liable for defamation by what is.
Oh, I called it. The judge references the Johnny Depp case, the Adam Waldman statement. This is feeling meta at this point. Wow. That was really interesting. The judge literally referenced the Johnny Depp case, and that's why he's focusing on and asking about these lawyer statements. That's wild. That's pretty wild.
Again, Your Honor, I understand that in certain contexts, the statements of an attorney could potentially be, lead to something like defamation. I agree with you on that. I think really what we're talking about here, though, Your Honor, is a statement by an attorney that even in and of itself is certainly not defamation, and it is not outrageous.
My understanding of the statement, and correct me if I'm wrong, is the Laundries knew, and again, this is on a motion to dismiss, so I have to accept what is alleged as true. Not that it is true, but I have to accept it as true.
The judge is doing that for the general public because he's about to say all of this stuff is true because that's how I have to think about it during a motion to dismiss. But it's not, I'm not saying it's true. They still have to prove it to win at trial. But at this point, I have to believe all this is true. So I want to make sure all of you, all the listeners and my channel understand that. He is not saying this stuff is proven to be true. He's saying in a motion to dismiss, that's how I have to think about it.
That the Laundries knew where the Gabby's body was. And they put out a statement in the middle of the search, hoping about the success of that search, and then not either directing them or either staying silent. I mean, that's kind of my understanding of what is being alleged. Is that correct, or am I misunderstanding?
No, I believe that's my understanding as well, Your Honor, that the attorney made the statement while the search was ongoing.
And knowing exactly where the Gabby's body was.
Well, Your Honor, again, that's the rub, is the plaintiffs haven't alleged anything in the complaint as to what the attorney's knowledge was when he made that statement, that he had that information. That's a totally different thing. They've alleged that the parents, the defendants, had that information, but they don't allege that that information was ever shared with the attorney, or that the attorney had that information when he made that statement. That's kind of the issue, is they haven't really made any allegations about the attorney and what he.
So a couple things that are interesting here. They're going to, if they ever amend this complaint, they're going to add the attorney statement, and we know that's coming. But number two, if you think back to the video I did on the motion to dismiss, and reading through the case law, I said the best case for the Petitos was the doctor who lied about how that person died. Doctor did surgery, screwed up, the person died. They lied to that person's family. It ended up coming out that they found out the doctor lied and actually caused the death. That was enough for intentional infliction of emotional distress because the doctor actually did something and said something to mislead them. That is where I think this attorney statement could actually come into play. Before I was like, what's the big deal? Well, maybe the judge is trying to connect it to that case. And I think the Petito lawyers should try to connect it to that case and say, no, this judge, just like that doctor, misled the Petito family and caused even more trauma and made it even worse for them. And therefore we should get to go forward on this claim. Very, very interesting connection here between people saying things that are misleading and potentially covering it up. Very interesting.
He may or may not have known. It's really all about what the parents knew. And they don't make any allegations about what the parents communicated to the attorney. So really the attorney's statement, again, if just looking at it within the four corners of the complaint, there really isn't enough there to say that whether or not when the attorney made that statement, what his knowledge was about any of the facts of the case, frankly. And I would also submit to you, Your Honor, that statement's fairly benign. I mean, I understand in the context that they've alleged.
I would argue the same thing, that statement is benign.
Trying to divert attention or something like that. But again, it's a fairly benign statement. I mean, he's really just expressing that he hopes that she returns. And again, they haven't alleged what information he had when he made that statement.
Isn't the context really what's important here? And that's what the second DCA said in that insurance case where the adjuster denied coverage and did so knowing that the person didn't have long to live and just wanted to outlive the person. And the second, which is binding on me, found that to be outrageous conduct.
That is true, though, Your Honor. In that case, the second DCA said that the actions of the insurance company in simply denying the claim, even though they had been ordered by a judge of compensation claims to pay the claim, that in and of itself would not have been outrageous. But what made it outrageous was that there was some sort of internal, decision made that they're just not going to pay it for a certain period of time in the hopes that the plaintiff would die. I agree with you that made that particular case, rise to the level of outrageousness. Your Honor, frankly, the statement by the attorney in this case doesn't come even close to that level of outrageousness. I mean, you're talking about, withholding medical care in the hopes that some.
Literally, you can construe what the Laundrie's lawyer said as condolences. So is that enough to mislead, basically, and to offer like good luck, basically, is what he said. That's tough for as far as outrageous, but you guys let me know. Do you think that's outrageous, that quote that he read from the Laundrie's lawyers?
Somebody dies, so you don't have to pay for it. I mean, I don't think any of us sitting here would not find that to be outrageous. We're talking about a statement by an attorney, sort of, boilerplate and generic, just expressing that he hopes that the search is successful and whatnot. I don't really equate those two. I mean, I do agree with your point, Your Honor, that the context is important. We do have to consider the context as alleged in the complaint in this situation. But I would just submit to Your Honor that even considering that context within the complaint, the attorney's statement is not outrageous.
You have about 5 minutes left in your argument.
Okay, thank you, Your Honor. So,
Told you this judge don't play. He's like, you got 5 minutes left, and then we're going to hop over there. Although I just looked in the queue, and it looks like he talks for more than 5 minutes, but we'll see.
I'll move forward, Your Honor. I know we filed a motion, and Your Honor has read it, so I'm not going to try to belabor too many points here. But with regard to the assertion of legal rights, really, the plaintiffs recognize that the Laundries have constitutional rights, and that the conduct that they have alleged within the complaint is really an exercise of those rights. So what they argue in response is that the court on a motion to dismiss shouldn't consider certain things. Number one, because they allege that within the complaint, they haven't alleged state action. Number two, that they haven't alleged any constitutional rights within the complaint. And so the court shouldn't consider them. And then fourth, that the constitutional rights are affirmative defenses. Your Honor, with regard to the state action argument, as an initial matter, just because the government isn't trying to compel someone to do something doesn't mean constitutional rights don't go away. If you don't protect your own constitutional rights, even when the government's not trying to do something to you, then you would likely waive them. If the defendants in this case had made a bunch of statements, even if those statements weren't to law enforcement, those statements could absolutely be used against them. So, in that sense, Your Honor, those rights exist, irregardless of whether the state is involved. Your Honor, also, as a second point, there is state action involved here. And one of the cases we cited to Your Honor in our motion sort of sums it up. It's Gerber versus Longboat Harbor, North Condo. It's a Middle District of Florida case from 1991. And that court said, defendant's motion to dismiss is predicated upon its assertion that, since it is not a governmental entity and has not assumed substantially all of the functions of a governmental entity, the provisions of the First Amendment as incorporated in the 14th Amendment simply do not apply. This court cannot agree with defendant's contention, and by applying the principles enumerated in Shelley versus Kramer, which is a Supreme Court case that sort of set forth that the third branch of government, the judicial branch, is also state action. This court found and continues to find that judicial enforcement of private agreements contained in a declaration of condominium constitutes state action and brings the heretofore private conduct within the scope of the 14th Amendment, through which the First Amendment guarantee of free speech is made applicable to the states. Now, obviously, we're not dealing with a contract here or a condo association or anything like that, but the point is the same, that when a party tries to use the courts to enforce something, then there is state action. And in this case, Your Honor, the plaintiffs want the court to enter a judgment against the defendants. They presumably will want the court to enforce that judgment, and they want to use the court's authority to compel the defendants to participate in the discovery process, all of which implicates their First Amendment, Fifth Amendment, all of their rights, Sixth Amendment right to counsel, So, Your Honor, in that regard, there is state action. I addressed the criminal investigation earlier, so I won't go through that again. Your Honor, with regard to the four corners of the complaint argument, like I said before, the Laundries are residents of Florida. It's alleged in the complaint. As such, the Constitution fully applies to them, and the court can consider those rights. The plaintiffs are essentially asking the court to force the defendants to go through discovery, pretrial proceedings, summary judgment, just to get to the point where the court finds that the defendants have constitutional rights. That's just a waste of judicial resources and the resources of the parties.
So he's hitting the argument I said, that the judge is almost indicating that at this point I can't dismiss it for the Fifth Amendment right, but later maybe I can. And he's saying, are we really going to do this and waste everybody's time and money and invade the privacy of the defendants? It's a good argument.
Your Honor, with regard to the affirmative defense, nobody cited any cases where the legally permissible element is labeled an affirmative defense. I certainly haven't seen anything where it's the defendant's burden to prove that if there were to be a trial such that it would be an affirmative defense. Rather the legally permissible element is really intertwined with the outrageous elements. In the seminal case of Metropolitan Life versus McCarson, which is the Florida Supreme Court case that established the cause of action. The court explained how
they have 1 hour total.
Said the facts as a matter of law are not so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency. Rather, the insurance company, according to the terms of the policy, had the right to demand proof of ineligibility for Medicaid, or for Medicare. And then it goes on and it says, Metropolitan did no more than assert legal rights in a legally permissible way. As such, Metropolitan's actions are privileged under the circumstances. So, Your Honor, it's not really a defense. It's really part of the outrageousness calculus, that the conduct isn't legally outrageous if there is a privilege or a legal right that's being asserted. And Your Honor, we cite some additional.
Elvira, I have it on 1.25 speed, so hopefully everybody can keep up, but just so we're not here forever because we're about 10 minutes behind. So I do have it on 1.25 speed. Don't hold it against Matt Luca.
Cases in our reply that I'll rely upon in that regard. Your Honor also said that even if this is an affirmative defense, which I don't think it is, the court can consider an affirmative defense if it is apparent from the face of the complaint. Your Honor, we would argue that constitutional rights are apparent from the face of the complaint. They allege a crime was committed. They allege an attorney was hired. So it's not a situation.
I stopped it because all of you guys are hating on him for it. It's not his fault. I don't want him to look bad. I put it back to normal speed. We can listen to it on normal speed.
Where the court can't consider the defendant's constitutional rights. And in fact, in the case Hazar versus Gross, which we cited in our papers, it's the first DCA case from 1985. It's a defamation case. And in that case, the court was considering a First Amendment privilege on a motion to dismiss and held that trial courts, upon motions to dismiss, routinely make decisions as to whether a privilege applies to protect an allegedly defamatory statement. So again, in that context, the court held that on a motion to dismiss, the court can consider a constitutional right of a defendant if that constitutional right is their defense.
Okay, well, let's just ask. I know you have identified what you contend is one crime, which is to actively assist Brian evade capture, essentially. Assuming, of course, that and not this is not within the four corners. I mean, we know outside.
He's like, do I have to answer that, Judge?
But not in the four corners. Is there an allegation that there was an arrest warrant out for him? But assume, for the sake of argument, that is sufficient for purposes of us to find that there was some sort of active crime, if you will. Is there any other crime that the Laundries have been accused of or could potentially be accused of? Because before you can invoke a constitutional right to remain silent, there's got to be a crime, right?
Well, Your Honor, there doesn't necessarily have to be a crime. You just have to believe that you may be in jeopardy of a potential investigation.
Well, doesn't the case law talk about it has to be a chain in the causation towards a crime?
Your Honor, I don't disagree with you on that point. What I'm saying, though, is there doesn't have to be a formal investigation. If I left this courtroom and committed a crime and nobody knew about it, I'm not obligated to go confess that crime. Like I can assert my silence for as long as I feel like I need to protect myself.
Well, let me ask you this, because the case law I'm familiar with is in a deposition, the Fifth Amendment would have to be invoked as to each specific question. So for instance, if the question is, what is your name? You might not have a Fifth Amendment right to not answer that, depending on the context of the alleged crime. So I get back to what is the crime here? And isn't that really something that we need more pleadings to be able to accurately identify so that I have a better standard as to whether or not your Fifth Amendment argument actually is applicable?
So if any of you were following the Ghislaine Maxwell case, when that juror who potentially changed their opinion on the jury questionnaire, the judge came and asked, and they had a little private conference about whether or not there was actually a criminal implication when they pled the Fifth. That's kind of what Judge Carroll's saying at this point. Do we know there was actual criminal implication, or did they just remain silent and they cloaked it under the Fifth Amendment, but maybe it wasn't actually under the Fifth Amendment? Do we need to dig into that more with discovery? Meaning, is this case going to continue forward and not be gone today?
I don't think so, Your Honor. I mean, certainly the plaintiffs have alleged criminal conduct, most of which by Brian Laundrie. I'll agree with that. But they do allege that the Laundries, potentially were trying to assist Brian Laundrie in leaving the country, which could be an obstruction, could be something else. There could be, again, we're not leaving the complaint when we talk about that. And so in that regard, the defendants still wouldn't have an obligation to speak about other things that may be sort of tangentially related to the whole situation, if there is potentially a crime involved. I mean, Your Honor, in Miranda versus Arizona, the Supreme Court held the privilege is fulfilled only when the person is guaranteed the right to remain silent unless he chooses to speak
Laundries.
an unfettered exercise of his own free will. So it's the defendant's exercise. It's not something where, the defendant can maintain his silence only with regard to certain things. If he's not being compelled to answer questions, he doesn't have to speak, period, at all. Again, from Miranda versus Arizona, the privilege has come rightfully to be recognized in part as an individual's substantive right.
It's wild,
A
man.
right to a private enclave where he may lead a private life. That right is the hallmark of our democracy. So again, Your Honor, it's not, in Miranda versus Arizona, the court wasn't parsing what questions the defendant can or cannot answer. They said the right is a private enclave where a person can lead a private life. They can maintain that privacy for as long as they're able. Now, of course, like there are certain situations if defendant is subpoenaed to testify, perhaps certain questions could be parsed, like what the person's name is or something, as long as that's not incriminating, which in some contexts it is. This is, again, going to the plaintiff's argument, they haven't alleged that anybody was compelling anybody to do something and they refused or something like that. In that context, everybody has the right to their private enclave. They don't have to come and affirmatively state everything they know about everything.
Definitely more than 5 minutes.
It's not the way our society works. It's not the way, it's not how the Constitution works. People are protected until they're not. And so that, in my opinion, Your Honor, I don't believe that the Laundries would have an obligation to provide certain information and not provide other information. That they can withhold all information until it's compelled of them. That's or they're provided immunity by the government or whatever the circumstance might be.
Hey, Deb Lou, if you want to go watch it on another channel like WFLA, they don't have anybody talking over it. But here, that's the whole point, is to talk about it, discuss it, add to it, make it our own video here. That's what we do on this channel.
Well, let's put a pin in that right now so I can hear from your opponent.
Yes, Your Honor. And Your Honor, for our remaining arguments, we'll just rely upon our papers unless the court has some specific questions that you'd like to address.
Thank you, sir.
May it please the court. Your Honor, this case is not simply about the silence of Christopher and Roberta Laundrie, who knew that their son had brutally murdered Gabby Petito. It's not simply about their callous refusal, despite pleas from the Petito family, to speak up about whether or not Gabby was alive and if she wasn't, where her body was located. It's about a course of
Coming out
conduct
guns
that
blazing.
they committed from the moment they learned on August 28th of 2021 that their son had brutally murdered Gabby Petito up until the time that her body was found. And as this court has already noted and pointed out, that includes the statement that was made the one time they decided to speak up. They spoke up through their attorney, and I'll touch upon the importance of that in a little bit.
So what do you do as a lawyer on the other side where you feel like the judge is with you on a certain point? You hammer that point, you stick to that point. He's mentioned it and he said he's going to come back to it.
As the court knows, you're bound to accept as true all of the facts alleged in the four corners of the complaint. And I'd just like to review what some of those allegations are.
Well, let me ask you this, Mr. Riley. And let's lay aside the statement that the attorney made on behalf of the Laundries.
Also, what shows a great judge is he can hammer one way on one lawyer. And then now with the other lawyer, he says, well, let's put that one statement aside. I want to see if there's anything else. Meaning he's not giving anything to these lawyers. He's making these lawyers make their arguments themselves. I love it. This judge, I mean, he's doing a great job.
What duty did the Laundries have to do anything to help Mr. Petito and Ms. Schmidt?
That's a fair question, Your Honor, and I've struggled with the answer to that particular question. And I guess maybe by answering this, I'm deflecting, but my answer is this. It's about what they did with the information that they have, not just not disclosing what they knew to the Laundries. And by the way, they could have, to the Petito family, excuse me, they could have made an anonymous phone call and said where the body was located, and that would have helped this situation tremendously.
That's a good point. They could have just made an anonymous phone call and they didn't. Now, again, there's a very important thing about duty, breach, and causation, right? In these cases, in these civil cases, do they have a duty to do that? Do you have a duty to make an anonymous phone call? And if the answer is yes, and the jury says yes, and the law says yes, then fine. But that was a good point.
They knew starting on August 28th of 2021 that Gabby was dead. They knew where Gabby's body was. They knew that the Petito family was desperately searching for information, but they did things affirmatively. They didn't just remain silent. Brian Laundrie came home in Gabby Petito's van by himself to his family's home. That family, knowing that Gabby was dead, knowing their son had murdered her, knowing where the body was, and in particular, knowing that Joseph Petito and Nicole Schmidt were desperate to learn where their daughter was located, they went on vacation. They assumed and continued their normal life as though nothing had happened, while this family was suffering, wanting to know what where their daughter was. Not only did she not.
Let's get back though to legal duty. I hear what you're saying.
The judge is like, I hear the facts. We don't need to talk about the facts. But at this point, let's talk about the law. That's what the judge keeps bringing it back to, which is the harder part for them. He talked about the harder part for the Laundries with the Laundries lawyers. Now he's talking about the harder part for Petito with Petito's lawyer, which is exactly what a judge should do.
These facts might sound bad, but we're not talking about social mores here. We're talking about legal duty.
We're talking.
So let's try to focus in on what duty did the Laundries have? What did they owe to Gabby's parents?
Well, let's put in perspective what the relationship was, Your Honor. These people were not strangers. These people were, their son was engaged to marry Gabby Petito. Gabby had lived with them for about a year. They had both visited Joseph Petito's home and Nicole Schmidt's home. They were cordial. They had a cordial relationship, a warm and friendly relationship. They knew how much Gabby meant to Joe and to Nicole. Going to the issue of a duty, Your Honor, I struggle with that. I admittedly, it's difficult to say what it is. And that's why I'm saying there was a course of conduct that they did that was outrageous.
So the big question the judge wants to know is, what is their legal duty? And the lawyer that filed the complaint says, I'm struggling with what the duty is. That's not a great legal argument in a legal proceeding like this. He's not explaining it to a jury. He's explaining it to a judge who is specifically asking about this. That's not great.
Culminating, in my view, in the statement that was made by their attorney, who, as Your Honor pointed out, is their agent. And what that attorney said in particular is telling. So there's no question that he represented, that he was making that statement on behalf of the Laundries, because he says, it is our understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming on behalf of the Laundrie family. It is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. That statement was issued with the full knowledge and consent of the Laundries, with the full knowledge on the part of the Laundries that Gabby was not alive and that Gabby's body was located somewhere out west. And instead, they make a statement saying, we hope you find her. We hope you're reunited, giving them false hope that perhaps their daughter is still alive. If that's not outrageous, Your Honor, I don't know what is outrageous. So I think when you talk about their affirmative,
I don't remember who it was, but somebody in this very chat said that same thing. They gave them a hope, and I put it on the screen. Giving them that false hope was horrible, and that's exactly the argument they're making. You give yourselves some credit. You guys can pick up on what a lot of these arguments are, especially in a case like this where he's veering a little bit away from the law and trying to stick to the very terribly sad facts.
duty to speak up, I struggle with that. But they did speak up. And when
Duty
they
to
spoke
speak
up,
up,
they
I
made
struggle with that because I don't think it
callous,
exists.
That very terrible statement, giving hope to Joe and Nicole that perhaps Gabby was still alive, with full knowledge that she was not. And Judge, when I talk about the course of conduct, I want to talk about some of the cases that I cited in my response to the motion where the court found that there was outrageous conduct. And I don't see how any of these cases are by any stretch of the imagination, worse than what happened in this particular case. In the McAlpin versus Sokole case, a patient went to a hospital to have an x-ray done. She put on a hospital gown. She walked into the x-ray room, and the minute she walked into the room,
we went through a lot of these
raised
cases
her in front of other staff because she hadn't paid another doctor's bill. He told her, hey, here's the story from the mother, spends the next 7 hours calling hospitals and police departments out in California, only to find out that this story was false. That was outrageous. The Dependable Life Insurance Company versus Harris case was talked about.
We read through all of these already.
Liberty Mutual versus Stedman. The company delayed authorizing a lung transplant, even though a judge of compensation claims had already ordered that they pay for the lung transplant. The carrier knew she would die without the lung transplant. So, hoping the problem would go away, they denied payment in an effort to intentionally induce stress on her part to speed up her demise. The court said, under the totality of the circumstances, it's outrageous. Williams versus Mineola, and it's these two last cases that I'm going to cite the court to that I think are most instructive here. In Williams versus Mineola, police officers attended the autopsy of a teenage boy who had been murdered or committed suicide, and they were there with a videotape, a video camera, and a camera to record it because of the suspicion that a crime may have been committed. They took that video, they took those photos, and they took them to a party. And at the party, they shared them with other persons, including other police officers from surrounding jurisdictions, and they laughed and they joked about what was in those photographs. The court found that to be outrageous, and here's what the court said. As for what is outrageous or reckless or what is not, we emphasize that our society, as reflected, for example, in decisions of the courts of Florida cited earlier in this opinion, shows a particular solicitude for the emotional vulnerability of survivors regarding improper behavior toward the dead body of a loved one, and the special deference paid by courts to families' feelings where rights involving dead bodies are concerned is central to our decision. This area is unique, and once it has entered, behavior which in other circumstances might be merely insulting, frivolous, or careless becomes indecent, outrageous, and intolerable. One obvious reason is that the bereaved are already suffering psychic trauma because of the loss of the loved one, and are especially sensitized to any disrespect or indignity directed at the deceased body or
A lot of you are asking versions of this question. Not yet. We don't have that evidence yet, but they're stating it as true because we're in the motion to dismiss phase. So the judge, when making this decision, has to take all the facts as true. This isn't a jury trial or a bench trial where we're going to have a final decision. Just, are they allowed to bring this to a jury?
to Gabby's parents that perhaps she might be alive. The other case, Your Honor, that I think is instructive is the Thomas versus Hospital Board of Directors case, and I think this one may be even more instructive. In that case, during I believe it was a hip transplant surgery, the decedent died. She died of cardiac arrest. What she really died, the real reason she died of cardiac arrest is because she was given an overdose of a particular medication during the surgery. And the doctors and the nurses agreed that they would not report the true reason for why she died. They would say that it resulted from complications of surgery. As a result, the complete autopsy was not done. The body was released to the family, and less than a week later, as the decedent's daughter was trying to bury her mother, she received a telephone call from the medical examiner saying, "You need to bring that body back immediately. We have to perform a complete autopsy." Again, the court said that was outrageous.
And he saved that case for last. And if you watched my breakdown of his response to the motion to dismiss, I said that is their best case, and that is what they should rely on. And what do you know? He says it is most instructive. Let's hear if he connects it to the lawyer's statements now.
And what the court said was, we believe that the appellee's conduct in making false statements, and isn't that what Mr. Bertolino did on behalf of the Laundries here? We believe that the appellee's conduct in making false statements, which led to the interruption of Mildred Thomas's funeral and the return of her body for a second, more thorough autopsy, rises to the level of atrocious and utterly intolerable behavior, which cannot be condoned in a civilized society. As noted in Stedman, when an actor has knowledge that the other person is peculiarly susceptible to emotional distress, and the Laundries knew that because this family publicly said they were distressed trying to find their daughter, the actor's conduct may become heartless, flagrant, and outrageous when the actor proceeds in the face of such knowledge. We believe that in a situation where a person's loved one has died, it would be apparent to anyone that the person would be susceptible to emotional distress, and therefore that the action of providing false information concerning the loved one's cause of death meets the standard for a claim of outrage. In this case, they provided false information, a false impression, knowing that Gabby was dead, that she was still alive and she could be found by the family if they were searching in the right place. So
I think he's making a lot of jumps personally based on that statement. But now this case has totally turned into a lawyer statement that was not even referenced really very much throughout the complaint. So it's very interesting how this is kind of twisting and turning here, but he is using the right case law as far as I'm concerned based on the briefs in this case. So we'll see what the judge thinks.
I also think under the restatement of Torts Section 46, comment F says, the extreme and outrageous character of the conduct may arise from the actor's knowledge that the other is peculiarly susceptible to emotional distress by reason of some physical or mental condition or peculiarity. The conduct may become heartless, flagrant, and outrageous when the action proceeds in the face of such knowledge, where it would not be so if he did not know. And that's basically what the Williams court was saying, and that's what I'm saying in this instance. The Laundries knew of the fragile emotional state of Joseph Petito and Nicole Schmidt at the time that that statement was issued. They knew that she was not alive. They knew that the family was hoping to find her, and they put out a statement as though they were supporting them, saying, we know she was our son's fiance. And we hope that you find that body too, or you find her and the family is reunited, excuse me. That's callous. That's callous, it's shameful, and it's outrageous. And by the way, the only reason that Mr. Bertolino is not a defendant in this action is because he's not a citizen of the state of Florida.
Interesting argument that you couldn't make in front of the jury.
Under comment E to the restatement, which says unequal position of the parties in a relationship where one asserts and has the powers to affect the interest of the other may also supply the heightened degree of outrageousness required for a claim of intentional infliction of emotional distress. Here, the defendants clearly had the power to affect the interests of the plaintiff because they could have told them where her body was located, and they chose not to do so.
Carol, we could, but it's unlikely. He'll probably reserve ruling, but he could.
There's a question. There's been nothing raised, at least by counsel in his argument, that the conduct didn't cause severe emotional distress to my clients, to the extent that they would suggest and have suggested, well, they were already distressed anyway. So all we did was increase their harm. I guess it's okay to kick someone when they're down, according to the Laundries. But going back to those two cases that I cited earlier involving dead bodies, the parties were already grieving, and it was the conduct after death that the court found was outrageous and permitted the case to move forward. So I think we have the issue of their conduct was intended to harm, or certainly what they did, they should have known was likely to cause severe emotional distress to my clients. We clearly have an outrageous conduct on their part. I think we have established that the conduct caused more emotional distress. It doesn't have to be the only cause of their distress. If it increases, that's sufficient to recover. And I don't think they're contesting at all that the emotional distress was severe. So I'll move on to the suggestion that the defendants get to raise affirmative defenses at this point in time.
Well, and thank you for doing that, because my question there is, I mean, the rule is that I can address it if it is apparent within the four corners, and effectively you alleged conduct which arguably could be considered criminal on behalf of the defendants. So why can't I consider the Laundrie's constitutional right to remain silent and other constitutional rights within the context of ruling on this motion to dismiss?
The judge asking the hard questions for both sides.
The complaint says the Laundries committed that was potentially criminal. So if the answer is they were harboring a fugitive, there were no charge. Again, we're outside the record, but to my knowledge, or outside the four corners of the complaint, but the complaint doesn't allege that there were any charges pending against Brian Laundrie at the time. So they couldn't have been harboring a fugitive. Are they?
I'm not sure the absence of charges is the criteria that we use.
Well,
Again, that's the judge asking a question that he knows the answer to, because the judge is right, obviously, in this situation. And I really like how the judge is really trying to hone in on a couple specific things for each side, because he wants to know, how are you going to answer these questions to help me make my decision?
Judge, what this is forcing me to do to address that is to go outside the record, which is not what we're supposed to do, to say he wasn't running. According to everything we know, the police knew where he was. So he wasn't a fugitive, so they weren't harboring a fugitive. I don't know what were the accessories after the fact. I don't know. Is there something they want to confess to? I'm happy to hear it, but I don't know that anywhere within the four corners of the complaint there's a suggestion that the Laundries were under investigation for a crime or that they had committed a crime. So first of all, I think we shouldn't even be considering this as an affirmative defense. Secondly, you can't look at the complaint and determine, was there an investigation into them and what were the crimes? So I don't think the Fifth Amendment applies. If we turn to the First Amendment, I will tell you I strongly disagree with counsel's assertion that it applies in all instances. The defendants rely on Woolley versus Maynard for the proposition that they have a constitutional right to say nothing. But Woolley says that the right of freedom of thought protected by the First Amendment.
He's literally reading out of his response here.
Includes both.
I'm going to jump just a little bit.
Moving money around to try to move them out of the country. I agree with you wholeheartedly that you could arguably consider a Fifth Amendment argument in this case. But there's nothing in there to indicate that there was any criminal conduct on the part of the defendant. There's a statement that says they were moving money around to try to get them out of the country. Is that unlawful as it's pled in this complaint? No, it's not.
Okay.
Going back to the First Amendment issue, Your Honor, it doesn't set forth an all-encompassing right to remain silent. Only where through state action they are being asked to espouse a religious, political, or ideological cause which they do not support do they have that right. And I will cite to you from one of the cases in my brief, my motion, the Overbay case, which says, freedom of speech includes both the right to speak freely and the right to refrain from speaking at all. At its heart, the right to refrain from speaking is concerned for preventing government from compelling individuals to mouth support for views they find objectionable or mandating speech that a speaker would not otherwise make. In other words, the court.
So now they're getting into the First Amendment argument, which I actually think is the Laundrie's potentially weakest argument. And RDub, yeah, I mean, this is the argument the Laundries are making. So we'll see if the judge agrees.
Legal prohibition on calling. Legal prohibition.
It's ludicrous. The First Amendment does not apply in this particular circumstance. We pointed out that they contacted counsel to show a course of conduct and to support our proposition that they knew that Gabby was dead and that they knew where her body was located as of August 28th. They immediately contacted an attorney.
I get back to where's the duty, and certainly there's no legal prohibition on calling a lawyer.
I'm not, Judge, I'm not going there.
Yeah, you better not go there as a lawyer saying there's a legal prohibition on calling a lawyer or saying that makes you guilty that you call a lawyer. You should not do that as another lawyer, because then you would not understand how the law works in our country. If lay people want to say that, again, emotional people have their experience, I understand that, but as a lawyer, he should never make that argument.
I'm not suggesting, I'm saying that's support for our position that they knew. That's circumstantial evidence, in my view, that's why it's in the complaint, goes to show that at that point in time they knew. I'm not being critical of them retaining an attorney. I'm not suggesting they shouldn't have. I like the fact that they retained Attorney Bertolini, and Attorney Bertolini said what he said on September 14th of 2021. So we're not saying they should.
He said he likes that fact. I don't know if I would say I like that fact. I would say it's a beneficial fact to our case, maybe.
Have hired an attorney. We're not saying hold it against them for hiring an attorney. I'm simply saying they hired one immediately after getting a phone call from their son, who then returned home without Gabby. Circumstantial evidence to show that they knew. That's the only reason that I raised that issue about them hiring a lawyer. Your Honor, unless you have any other questions, I believe I've covered everything I wanted to cover.
Thank you very much.
Thank you.
Mr. Luca, I'll give you 2 minutes for any brief reply, but let's keep it to 2 minutes.
Yes, thank you, Your Honor. Your Honor, one thing I would point you to with regard to that city of Mineola case, Your Honor, there is a second DCA case, Crenshaw versus Sarasota County Public Hospital Board. I think it's cited in both my motion and
Luca gets to go again here, the Laundrie family, because it's their burden on the motion to dismiss to try to win. So just like in the case where you guys have watched trials, whoever holds the burden gets to go first and last.
And the plaintiff's brief. And in that case, Your Honor, that case also involved a dead body, a stillborn child. And basically what happened is after the child was born, deceased, somebody within the hospital mutilated the child. It ended up going down a laundry chute. And in that case, Your Honor, importantly, the court noted that obviously if the mother had witnessed all of those terrible things that happened to the child, that might be one thing. But the court noted that the physically injured party should be directly involved in the event causing the original injury. If such a person sees it, hears it, or arrives on the scene while the injured party is still there, then that person is likely involved. And then they go on to say, here, appellant did not allege that she saw the mutilated body or that she was involved in the event, except for the birth of the stillborn child in any way. So, and Your Honor, that Stedman case was cited in Mineola, and in Mineola, the 5th DCA said that to the extent that Stedman conflicts, they're not going to follow Stedman. But Stedman would control here because it is a 2nd DCA case. And lastly, Your Honor, I didn't raise this, get time to raise this initially, but I would point Your Honor to another important case, which is MM versus MPS. It's a 3rd DCA case from 1989, again cited in the papers. And although not perfectly analogous, that case is instructive because it involves the parents suing the defendant for something that was done to their daughter. And in that case, the defendant told the parents that he had sexually abused their daughter, but obviously the parents were not present for the abuse. In that case, the court found that the appellants were not present when the alleged mistreatment of their daughter took place and may not claim emotional distress for her injurious or offensive treatment. Now, the plaintiffs countered that the disclosure of the treatment of their daughter was what caused their emotional distress. And the court said, after reviewing the law, we are unable to conclude that learning the awful truth from the defendant afforded appellants grounds for recovery for their own distress. And the court said, if courts were to allow relatives of tort victims compensation for the distress they suffer when they receive bad news about family members, when there is no attendant intentional or reckless conduct directed toward them, an avalanche of litigation would ensue. Compensation is available for actual harm to the victim.
That's literally what I said off the top and what I've said throughout. That is the state of the law in Florida, whether we like it or not. Beverly, right now, I think my prediction is actually that the judge is going to deny the motion to dismiss. That's how I'm feeling right now. If it changes, I'll let you know.
Only in carefully prescribed circumstances is compensation permitted for relatives who suffer emotional distress. It is not lack of compassion, but necessity that restricts relief to the immediate victim. And Your Honor, in this case, I would just submit to Your Honor that allowing a cause of action like this to proceed would create an avalanche of litigation that the tort was never intended to cover. Thank you, Your Honor.
Thank you both for your arguments. I will do my best to get a written order out within 2 weeks of today. Anything else in this first case before we recess the first case?
No, Your Honor.
So we'll have an answer within 2 weeks.
Yes, sir.
I don't represent any parties in the second case, so.
That's fine.
The second case is the wrongful death case.
Is cleaning up. Is there anybody that's going to be here in the second case, which is Nicole Schmidt as administrator of the estate of Gabrielle Verona Petito versus Barry F. Spivey as curator of the estate of Brian Laundrie, case number 2022 CA 2115 SC.
Your Honor, Patrick Riley on behalf of Nicole Schmidt as personal representative of the estate of Gabrielle Petito.
Okay. And has anyone appeared for the respondent?
No one, to my knowledge, has appeared. As Your Honor knows, Attorney Spivey, there was an order entered at the request of Attorney Spivey that because it was the Laundrie family who filed the objection to the claim that was made against Brian Laundrie's estate, they should defend the action. An order was entered appointing them ad litem to defend the action. It's been more than 20 days since I served the complaint on Mr. Spivey, but out of an abundance of caution, I'm giving the Laundries a period of time to respond, although the information that I have is that they are not going to and that a default will be entered.
All right, so this is a totally separate case with separate issues, so I don't really want to jump into these now. This is the wrongful death case. We can do a separate video on that one. But let's get to the press conference of this lawyer and hear what he has to say.
Coming outside of the courthouse. There you see Nicole Schmidt, her husband.
And Nicole Schmidt, we just want to express our thank you to Judge Carroll for the time he gave us today on the motion. We appreciate the time it's going to take him to make his decision. And we have no doubt that he will make the correct decision. The family will not be taking any questions, but I'll do my best to answer a few questions if you'd like.
How do you think the court hearing went today?
I was very satisfied and pleased with the question the judge asked, in particular about the statement that Mr. Bertolino made on behalf of the Laundrie family, because that says a lot. The fact that they knew she was deceased, they knew where her body was located, and they had the audacity to express a hope that she would be reunited with her family.
How is the family holding up through all this?
As best I can tell, they're handling it as best they can. If you saw, there were some tears earlier today when we came in here, and I expect there will likely be some more tears.
I know that the family isn't taking anything, but I noticed Nicole was holding on to her necklace. Are you able to share what that, if there's a meaning behind it?
It's Gabby's ashes. I'm sorry?
And the card.
Oh, it's a mass card. It's a drawing or a piece of art that someone from Australia, I believe, created utilizing a picture of Gabby. And on the back of it is a prayer that Jim wrote.
The defense alleged that they had a Fifth Amendment right, even though there was no criminal allegations. How do you feel about that? I heard you arguing about that in the motion to dismiss.
Well, there has to be an investigation or a crime before the Fifth Amendment right applies. I don't know, and I'm waiting for the day for the Laundries to tell us what crimes.
No, there does not. No, there
I'll
does
know
not.
that someday, but I don't know what crimes they are asserting were committed. We did allege that they were trying to move some money around and get Brian out of the country, but there was no arrest warrant out for Brian. He wasn't a fugitive. From a criminal law perspective, I don't think that there was anything inappropriate about what they were doing at that point.
He doesn't know what they were doing. So there could absolutely be crimes. You absolutely do not have to have a criminal investigation to have a Fifth Amendment right.
Setting not to see the Laundrie family present today?
I think for the Petito family, it was a relief. But I would like to have had them be in the courtroom and face the people that they caused harm to.
How confident are you this will go in your favor?
Well, as I said, I like the questions the judge was asking opposing counsel about the statement that Mr. Bertolino made. If someone doesn't find his statements, knowing all the facts that were known to the Laundries at that time, if somebody doesn't find that offensive and outrageous, I don't know what's outrageous.
Did you read anything into the judge saying only 2 weeks to give a decision?
No, judges typically take cases under advisement when there's a lot of research and a lot of cases cited, and so I'm not surprised by that at all. I'm surprised it's only 2 weeks. All right, thank you, everyone.
All right, so we are done with everything there. I am going to get to questions now. Overall, very interesting hearing. I'm leaning toward the judge denying the motion to dismiss based on the lawyer's statements, but maybe he will grant the motion to dismiss with leave to amend, so without prejudice, and we will see about that. Bev asked if I have time later to stream Can I tell us about the woman shooting, killing, and the home intruder in Clearwater, Florida this AM? I did not see that. So why don't you shoot me an email with that case? So I'm not sure which one you're talking about. So the one statement they made is used against them, KO. That's what it seems like, but they making it through their agent. Temp, are you joining Andy at Popcorn Planet at 4 o'clock, the live on this now? I have not gotten anything from Andy. I do have a call at 4 o'clock. So if he wants me to come on, I'm happy to, but it'd have to be after my appointment. If they had knowledge of her death before she was found, will they be charged with impending an investigation? Why not take that path first? Somebody else, other people have asked about criminal investigations, and Corona Dave asked, is it a fact the Laundries knew she was dead when their attorney made the statement? And I can understand why all of you are thinking that based on how this attorney is talking, but the real truth is those are not actually facts that have been proven yet. Those are facts that are alleged, and the judge has to take them as true. It's a very difficult thing sometimes for people to process that none of it's been proven, none of the evidence has been shown. But in order to see if they can get past a motion to dismiss, a judge has to take those facts as true and see if everything is true, can they prove this case? So the judge assumes they're true at this point, but no, they have not been proven. Bev, Judge Penny has wrecked me for life with regard to hearing immediate opinions from the court. That's during a trial. That's always what happens. I promise you, Judge Penny, just like all the other judges, take time to answer big hearings or big motions like motion for summary judgment, motions to dismiss. A lot of times they will take time to answer those. Temp, Peter, have you spoken about the incident with the Justice of the Supreme Court on one of your videos? I have not. I might have missed it. Became the max member I could. Awesome, Temp. Welcome to the membership team. I am glad that you guys, I'm glad that you're here and that everybody that's joined, we have fun. We have fun here on this channel. Okay. I'm going to try to hop over to JB's channel for a few minutes, answer some questions over there. So head on over to WFLA. Thank you everybody, for coming here. Hit the like button on the way out. Subscribe if you haven't already. KWN. I would ask the lawyer if he believes hiring a lawyer is evidence of guilt, if that also applies to his past and current clients. He did not go that far. Thank God. He did not say that. Azam, sorry, Peter, off topic. If a motorcyclist died after accidentally hitting a log that fell out from an overloaded truck, is this wrongful death? Happened in my country? Yes. In our country, yes, it would be wrongful death. The truck where the log fell out would be at fault for that. Yes, in most cases, I should say. That's a general question. JB is the host of the WFLA 8, which is a local news station here. That's where I'm jumping out to now. So you guys want to check us out there, hit the sub button and hit the like button on your way out. Thanks everybody for joining us for this stream. It was fun.